RTI is a law which has ensured the citizens their right to know matters pertaining to the governance of the country, has been revolutionary in the true sense of the word. For more than a decade now, the RTI Act has shown the country how significant the right to know is for a vibrant democracy. The Central Information Commission was constituted in December 2005 under the Right to Information Act, having jurisdiction over all central public authorities. An institution of immense significance, it had Shri Wajahat Habibullah as its first Chief Information Commissioner. He is responsible for building it up from the scratch, and the institution of CIC has proved its significance for the practice of true democracy in the country. We are glad to have Shri Habibullah with us, who has kindly agreed to deliver the first K. Padmanabhan Memorial Lecture on Right to Information. Dear Sir, may I request you to please deliver the lecture.
Honorable Justice Balakrishnan, Honorable Justice Rajan, Mr. Joe Abraham, Mr. Shivne, sorry if I'm not able to pronounce it correctly. I'm honored that you have invited me to come and speak to you, and that's what I intend to do. I don't intend to restrict myself to simply lecturing, but to speak to you about the Right to Information Act, which is something that has become dear to my heart, as you might imagine, and I know is dear to you. I'm particularly honored that you have Justice Balakrishnan here as chairing the session, because, of course, as you know, as has been announced, Justice Balakrishnan was Chief Justice of India for the largest part of the time that I was Chief Information Commissioner. I took over in 2005 and we met in 2010. But we also, earlier in our career, served together in the distant islands of Lakshadweep, where I was administrator and he was a young, strapping sessions judge. So, a lot has been mentioned about the strength of the RTI, but the legal foundations of the RTI Act owe a great deal to the work of the Supreme Court under the leadership of Justice Balakrishnan, because that strengthened the foundations of a law which is entirely new at that time. And not everybody was particularly sure, including myself, as to whether that law would really be of much use in accessing the secrets of which government has so many. But this law is in fact the culmination of a whole dream. And that is best expressed in the words of the father of the nation himself, Mahatma Gandhi, when he said, "The real Swaraj will come not by the acquisition of authority by a few, but by the acquisition of capacity by all to resist authority when abused." How is authority to be resisted when abused? Further expansion of this idea came more recently, when Justice Barack Hussein Obama took over as President of the United States of the US. In his first address in 2002 to senior officials of his government, he said, "A democracy requires accountability, and accountability requires transparency." Here you can see a resonance of the Mahatma's words. To resist authority when abused. How to resist authority? Ensuring accountability. As Justice Louis Brandeis wrote, sunlight is said to be the best disinfectant. In our democracy, meaning the US democracy, the Freedom of Information Act, which encourages accountability through transparency, is the most prominent expression of a profound national commitment to ensuring an open government. We can say the same for our Right to Information Act. And what is the significance, and what I want to bring across to you today, is that the heart of that commitment is the idea that accountability is in the interest of the government and the citizenry alike. Very often, and unfortunately even by people within the government, the Right to Information Act is looked upon as an assault on the government, as an intrusion into the routine functioning of government. The government needs to recognize this point made by no less than the most powerful head of state in the world, which is the President of the United States, who feels that no, it is a means of strengthening governance. And how is it a means of strengthening governance? That I hope to illustrate as we go along. But this is because it makes governance inclusive. Now you will recall that during the last general elections, our present ruling party, its manifesto and the statements of our Honourable Prime Minister repeatedly were limited government, maximum governance. Maximum governance would mean inclusive governance. Government is exclusive. Governance is inclusive. And how do we look upon that in the present state of development of our own country? The infrastructure now is increasingly being carried forward with privatization. Previous government institutions are being privatized. There is also what you call the public-private partnership. Public-private partnership in implementing government's development programs. Employment growth, unfortunately, has been growing less and less. Whereas it was 2.1 in 1984, and it was 2.1% in 1984. It had dropped to 0.4% in 1983. Hence the need for NREGA. And hence also the need to make NREGA fully accountable and fully transparent. Health services, a major challenge, being now addressed by the Government of India. Here we have some of the best hospitals in the world, available in services available at highly competitive prices, so that people across the world, including from our neighborhood, find that they get the best medical facilities, the best medical attention in this country at reasonable prices. Yet, we have the highest rate of infant mortality, we have the highest rates of malnutrition, not only in terms of numbers, that of course they will be because we are the largest country, but also in terms of percentages. And here we have people talking of the fact that we are on the verge of eliminating poverty, with the highest rates of child malnutrition in the world. That is not the elimination of poverty, but there is a means towards elimination of poverty through the instrumentalities that we have with us. We have, and particularly in the state of Kerala, widespread facilities for education. Yet, the standard and the quality of our education has been the subject of criticism. And therefore, although we have now virtually universal literacy, levels of excellence in education continue to elude us. Even though when children educated in our country go abroad, they are able to make their mark wherever they have gone. Then there is the access to justice. And here we have a distinguished number of people, and you yourselves are all activists or workers in the legal infrastructure of the country. So I don't need to tell you anything more on this. The injustices in our system of justice are apparent to all. Then we have this major vexing question of national security. I often cite the example of 26/11. Would the damage done to the city of Bombay, to our people of Bombay, could it have been better controlled had the people had better access to information? Had the media not gone about drumbeating their own access to information, which information should not at that time have been disclosed at all? So these are all examples of where inclusive governance can bring the people into the heart of the devising of development, of growth, and of all these security, which can help not only the country to become more democratic, but in every way strengthen both the country and the concept of governance itself. There are four basic imperatives of leadership as defined by the eminent management expert Steve Covey in his seven habits of highly effective people. The first is to inspire trust. The second is to clarify purpose. The third is to align systems. The fourth is the fruit of the other three, which is unleash talent. Now, I don't have to explain to you how key to all these principles of leadership is information. Without information, none of these can be achieved. With information, all these can be achieved. And so, our country has moved slowly but surely towards an information revolution, starting with the words of Mahatma Gandhi, but because we inherited a colonial infrastructure on our independence, a principal law of which was the Official Secrets Act, passed in 1923. And all of you, of course, being fully conversant with the law, will have read the law, and will realize that the law is structured, and says so in its aims and objectives, of keeping information away from the people. It says quite clearly that if people have access to information, they will become dangerous to government. But of course they would have been, because at that time the people were aspiring to freedom from the British. But now we have a government which is our government. And so the relevance, the need for laws like the Official Secrets Act is already is entirely redundant. Now we need laws by which the people can reach out to the people, not keep away from the people. And that is what the Right to Information Law seeks to bring. And that is how we seek to make governance more effective. In practical terms, it means that down to the level of governance, which you know now we have a 3-tier system, we have a Panchayati Raj system. Kerala has done very well in promoting the Panchayati Raj system, but still the marriage between access to information and local self-governance is far from complete. So what requires to be done is closer interaction between the right to information law and local self-governance. And mind you, it is defined under the Constitution. The Panchayat is defined an instrument of self-government. Here we have huge movements in Northeast India, in J&K, for self-government. We already have self-government in our Constitution. But the question is, are we able to exercise that self-government? And persons like Mr. Padmanabhan, who we are honouring today, well understood that we are not being able to exercise the openness and freedom, which is our aspiration, but it is also our constitutional right. And to help us to do that, we have the right to information law. It is for this reason that the UN Secretary General, Kofi Annan, described information as follows: the great democratizing power of information has given us all the chance to effect change and or alleviate poverty in ways we cannot even imagine today. Our task, your task, and this is as if he could be speaking to all of us, is to make that change real for those in need, wherever they may be. With information on our side, with knowledge of a potential for all, the path to poverty can be reversed. And as you know, the main thrust, the main objective of our entire socio-economic development plans since we became free has been the elimination of poverty, and yet poverty levels in our country are still unacceptably high. Can the Right to Information Act act as that kind of instrument of finally ridding us of the poverty? It can. But is it? That is the question that you must put to yourselves. What is information? Information is clearly defined in the Act. And I read it out to you because very often it is not properly understood. It means any material in any form, including records, documents, memos, emails, opinions, advices, press releases, circulars, orders, logbooks, contracts, reports, papers, samples, models, data material held in any electronic form, and information relating to any private body, mind you, which can be accessed by a public authority under any other law for the time being in force. Now, two things come out of this. One is that information is not a mere thought or a mere aspiration. It is something which is held in material form. It must be actually there. So it's not a question of asking questions and they saying I didn't get an answer because it wasn't suitably explained to me. There's no question of explanation. Here is the information, here you have it. Derive from it the meaning that you will. But the other aspect is that it is not really entirely restricted to government, even to the executive, judiciary and legislature. It goes beyond that. The principle being that any organization, be it the government or the private sector, which is benefiting from public funds, becomes answerable to the public. Why? Because they are in the pay of the public. And the public is paying GST, is paying income tax, is paying customs. All this money is coming from the public. Therefore, all these institutions are actually the property of the public. That is the key element of the Right to Information Act. When it improves governance, as I am arguing, it is improving the kind of governance that the public can demand on the basis of, in actual terms, paying the money for it. The key concepts, therefore, are transparency and accountability, as I have mentioned, giving equal access to every citizen, no matter what his or her social status. Placing a duty on government to disclose whatever information it can proactively, and not seeking to deny information unless justified by law. Not because I feel I don't want to give this information, but because the law exempts certain types of information from disclosure, and that is necessary in running governance. There will always be areas which cannot be disclosed either prematurely or even after the event, and certainly cannot be disclosed for a certain period of time, which is reasons already been there in the Act, and I don't need to explain those to you in greater detail. But the principal feature of this law, which I found, was it is not the property of government alone. And here you have seen, as you are doing, actually the public, civil society, standing up for the law. Repeatedly, when the government, including the government which actually brought the law, the UPA government, sought to amend the law in ways which were considered to weaken the law by civil society stood up, thereby compelling the then Prime Minister to concede that if we wish to amend this law in the future, we will only do it after public consultation. I think it is perhaps the only law of that kind in our country, which in itself has a huge plethora of laws. Therefore, what is necessary and what is a major shortcoming in the implementation of this law now is that the government must stand up to its principal obligation under this law, which is contained in Section 4. Every public authority shall maintain all its records duly catalogued and indexed in a manner and form which facilitates the right to information under this Act, and ensure that all records that are appropriate to be computerized are within a reasonable time and subject to availability resources computerized and connected to a network all over the country on different systems so that access to such records is facilitated. What this means is, of course, computerization of all records to provide easy access, that is one aspect. But that the government should suo motu, this is clearly laid down in Section 4.1b, should suo motu declare a host of matters of information on the website through their publications to the public. So it will not even become necessary for the public to actually approach a government department or a public authority seeking to have an answer. And this is also one of the few laws in our country which is based strongly and firmly on information technology. For disclosing information, for asking for information, and for keeping records of information. So these are some of the strengths of the RTI Act, and particularly Section 4, had it been fully enforced, then much of the pendency which is now there, it has been calculated about 80% of matters, of applications which come seeking information under the RTI Act could otherwise have been answered through simply suo motu discrimination. But as former President Dr. Abdul Kalam told me when I spoke to him, and he had always been keen that every ministry, every department should have its own website. I said, now all of them have got it. But he said to me, yes, but they're all out of date. So they have to be kept up to date. It's not laid down, specified in the law. It has to be updated every 120 days. These are not being done. This is where all of you, young lawyers, can be active and demand from the government, demand from the departments, that where are your websites? Where is the information which is required by the law? And why am I asking you to do it? Because unfortunately, the law itself, the Right to Information Act, for all its strengths, has this major weakness. There is no provision for the enforcement of Section 4. The furthest I could go as Chief Information Commissioner was to advise, and under Section 25, the Information Commission can advise all public authorities to actually take some action under the law. And that was the advice that was given to me. But that advice is simply as advices are, not something which is punishable, or which is a violation of which is punishable by the law. I think that with these words, I should like to conclude by once again reverting to the principles laid down by Mahatma Gandhi in the running of a modern society, free from the temptations and the corruption to which we are now subject. And you will recall that he defined this as the 7 deadly sins. I will read out these 7 deadly sins to you, just to remind you, to illustrate how the Right to Information Act is a means of actually addressing each of these. Wealth without work, pleasure without conscience, knowledge without character, commerce without morality, science without humanity, religion without sacrifice, politics without principle. And how do I say the right to information has something to do with all of these? Because there is no means of knowing that wealth has been achieved without work unless there is information. There is no means of telling whether politics is without principle unless you have information. There is no means of knowing that science is applied without humanity unless you have information. So that is the key, both to a moral society as well as to a society which is forward-looking and in which people are active participants in government.